The next case is 2023-259, Honeydew Associates, Inc. versus John F. Kennedy. We'll hear from counsel for Mr. Kennedy.
May it please the Court. The case before you presents a classic case of statutory construction, with the exception of the fact that we don't have a legislative history because of the delegation of legislative powers to the governor by the CDA and by decision of the Supreme Judicial Court. The case involves a business that was a small location, and it's worth describing it. There was approximately 153 square feet available for the public beyond with the kitchen and storage areas and bathrooms and the like. And it wasn't as if it was a 12 by 12 or so area. It was divided up into an entryway, one entrance to this location that was 3 by 11, roughly the distance between that bench there and the bar, and for that distance. And then there was a dog leg of an aisle that was 4 by 30 feet that led to the bathrooms in the back. That 4 by 30 feet would approximately be the distance from the back of your chairs and the width of the bench. And that's what the business had to work with in terms of accommodating the public.
Right, but here your client didn't communicate with the landlord, right, and raise this was a concern. They just didn't open.
The landlord, you say?
Yeah.
Oh, there was communication?
The Honeydew. They didn't
the
communicate with the
franchisor.
franchisor.
There's not any in the record, so I'm not going to go outside the record there. But the question was, could the business continue and comply with what the Supreme Judicial Court said was the law, which is the governor's mandates and his orders?
So your reading, or your client's reading of the governor's order is that if you couldn't comply, you couldn't open, period.
Yes.
Their reading is if you can't comply, you're supposed to do the best you can.
Well,
You're supposed to do the best you can to comply. It's only suggestive, which is what the judge agreed with.
I would phrase it a little bit differently, although I don't disagree with you. Their reading is you don't have to comply. It's purely aspirational. Mm-hmm. It's purely optional. And this, in the context of an order which, in accordance with statutory interpretation, must be read as in its whole to determine the meaning of any particular clause in it. Throughout the order, businesses must comply with the requirements in Section 2. That's on page 6 of the order. Page 2 of the order must comply with rules and standards pursuant to Section 2. If rules, standards, comply, requirements, it just doesn't square.
But yeah, but it was must comply. That's true. But as I read the social distancing aspect of the order, and this is the May 18th order, it says all persons, including employees, customers, and vendors, should remain at least 6 feet apart to the greatest extent possible, both inside and outside the workplace. So it was certainly not something that was mandatory.
You're reading from the...
Is that the May 18th?
Yes.
2020 order?
Provision there. Of course,
Page 3 of the order itself? So in other words, it was
should and shall.
Mandatory compliance with a non-mandatory provision, basically.
Well, if it's... Yeah, but how can you have penalties, which this has? Fines, injunctions. By the way, many of my other clients, I've fought these orders before, were subject to injunctions and fines and penalties. There are plenty of cases out there on all aspects of this, on masking, on distancing, etc. Now we're being asked by a franchise company here and by the Norfolk Superior Court to look back on all those businesses that had to shut down because they couldn't comply or got sanctioned by the authorities for not complying and say, oh, that was all purely optional.
Well,
These
do
were
you
just
have any
goals, aspirations.
Well, but I mean, if you look at page 3, it says you must adopt a policy, but then the policy says you keep people 6 feet apart to the greatest extent possible. So I think I think there's a mandatory aspect here, which is you have to have a policy, and then the policy says to the greatest extent possible, and that's where you have flexibility. Do you have examples of administrative actions where businesses were punished because they couldn't keep people 6 feet apart?
I have a case where that was part of the dispensation. It's pending again on appeal in front of the appeals court.
Which case is this?
This is Blondin, Town of Oxford versus Blondin.
Town of what?
And that case was a case involving primarily whether the gym facility could remain open, but they were subject to, during the course of the case, an injunctive order that required them to maintain certain distancing in accordance with the governor's other orders. So, as I said, courts were issuing injunctions on the basis of this. Page 6.
Can I ask something here? This isn't really outside the record. If we reverse this, it goes to a trial. So does the fact finder decide what the order means?
No.
Statutory construction?
The fact finder would decide whether the defendants could comply with the order. If the order is maintain social distancing of at least 6 feet, the fact finder can determine whether you could do that given the dimensions of this location, which, as I've already described, are plainly impossible to maintain any social distancing.
In front of the judge in, I believe it was Norfolk, there was nothing presented regarding a nefarious intent or anything on the part of your client,
Oh, no.
correct? That he didn't or she didn't want to open or there was money problems. None of that was presented to the judge.
No.
So the argument is that your client thought he couldn't open, and I apologize if it's a she couldn't open based on this order, so she didn't, period.
Yeah. Just like hundreds of other businesses that closed forever because of this. Some of them within walking distance of this very courthouse. Some of them were well-known businesses, and especially restaurants, that had been around forever. If you didn't have a delivery business or you didn't have a drive-through or a large footprint, you couldn't comply.
Is there anything in the record either on appeal or that the judge considered regarding the contract that existed between Mr. Kennedy and Honeydew Associates and otherwise the franchisee contract?
Only insofar as the liquidated damages were concerned.
So there was nothing presented about a force majeure clause about whether this applied or didn't apply?
No. That was not part of the summary judgment, although I concede that those things could be applicable. It wasn't part of the decision or the presentation. I would like to direct your attention to page 6 of the order, and it says the order is intended to establish a uniform set of COVID-19 workplace safety rules. Uniform set. If all we're doing, or all the governor was doing, was asking the business owners to, well, comply as much as possible or try to strive for this goal, it doesn't matter how far you attain to it. You don't have anything remotely resembling a uniform set of rules. All you have is an aspiration. And how do you enforce it? The order talks about enforcement.
If you could leave the public out of it for a minute, could you have 2 employees in this facility that could, reasonably maintain a distance of 6 feet from each other?
The employees from one another?
Yeah.
No. That was part of the record down below. As bad as it was in the public areas, behind the counter was even worse because it was a small cramped area where the employees in a coffee shop have to be going and getting milk and ice and whatever and crossing paths, and I don't even think they could be 6 feet apart at any time, much less on top of one another most of the time. You couldn't maintain the distance between the employees and the customers, although I suppose you could if you put up a barrier, a long counter or something, and slid the drinks over. But then you'd have even less room at the entranceway.
In any business serving the public, I mean, people did approach, say, a cash register or something, but I think that's the argument he's going to make, is that it's just to the extent possible. And so here he's going to say you could be open because the customer could just, even if you just had one customer and everybody else waits outside, the customer would come in, make their payment. It would be a very short transaction. It wouldn't be like the 15 minutes you usually need to have to be exposed.
Well, I think that the argument that's really being advanced on behalf of the appellee is that you can read the word "or" into it, at least 6 feet or to the greatest extent possible. If you read the word "and" into it, at least 6 feet and to the greatest extent possible, then of course it favors my argument. That's in addition to all of these provisions within this order shall be required, full compliance, must comply with the safety rules, must comply with the requirements. That is how the order should be interpreted, as a mandatory order with penalties, and that's in some way enforceable.
Is there any way that we could read this order as ambiguous? And if we do, what happens then? Who wins? We say, we agree it could be read the way you read it, but we also agree it could be read the way he reads it.
I wouldn't agree with your characterization of ambiguous. I would agree insofar as it's not as well drafted as it should be, which is one of the problems that occur when you abandon your legislature. And
well, I have to say sometimes the legislature statutes aren't exactly the greatest written either. But again,
at least with the legislature, we get public comment, we get debate,
back to my
all those
question.
things.
What if,
we didn't get that during COVID.
What if we say there are each way is an equally valid way of reading this? What happens?
Well, I would say that becomes a jury question at that point in time. If you can't, if you
decide what that means,
if the court can't decide it as a matter of law, then it goes to the jury. What a reasonable person would interpret in the light of all the circumstances.
This kind of goes to Justice Henry's question, and if you already answered it, forgive me, but I'm sympathetic to what you're saying in a sense that it seems like a harsh result here for someone who's making a good faith effort to comply with the governor's order in a very uncertain time that it was. Is there anything in the record that indicates that your client notified the franchisor that the regulation or the governor's order was being read in this fashion and was not abandoning the property and was just trying to comply with the order?
It's not in the record.
I'm not sure it would make any difference, but it's kind of a curiosity. Because, like I said, the result seems kind of harsh, and if it could have been avoided by some communication.
Well, that requires us to speculate, unfortunately. I will say this. It's ironic that this is coming out of the Norfolk County courts, because Norfolk County itself, during this same period, and thereafter for some time, spent a fortune to lease out Lombardis on 128 for their jury trials because they determined their courtrooms, as large as this, couldn't properly social distance. That's, we're a few years away from what this was like back then. But there was enforcement. There were injunctions. There were all these standards in this order talking about uniformity. And
counsel for the other side is going to say there were also plenty of places that were opened during this time frame, similar, maybe not exactly the same, as your clients. Restaurants were opening at this point.
The businesses that were open were big box stores that had food service, large footprint restaurants, drive-through restaurants, and places that had delivery. Just about everybody else folded shop for good, and including some businesses with a lot of more floor space than this. Zygamates over in the Leather District, the Fours down here. I could go on and on and on. It was devastating to the business of this Commonwealth, and I just don't think it's fair to them or to my client to turn around and say, "Oh, it was all optional."
Thank you very much. We'll now hear from Mr. Mickles.
May it please the court, I'm Jack Michaels. I represent Honeydew Associates, Inc. And I'd like, if I may, to begin with the question raised by Justice Henry and picked up later. There was no notice to Honeydew that the shop was going to close. The record is clear on that. It closed in March when the first COVID order ended. And there's an argument that's not material here as to whether or not a coffee shop is one of those emergency types of businesses that was supposed to remain open during the COVID pandemic. But Honeydew elected not to raise an issue about franchisees like the defendant who closed down in March. Now, the March order was rescinded in June, and this new order came in. And the new order has the language that we were just discussing: all persons, including employees, customers, and vendors, should remain at least 6 feet apart to the greatest extent possible. Now, when we started with summary judgment, the defendant argued that this was a mandatory clause, and they quoted the section, but they left out the words "to the greatest extent possible." Now they're coming up with the argument that, oh yes, those words are in there, but they actually help us. But the key word is not "to the greatest extent," or the key phrase is not "to the greatest extent possible." That certainly indicates try your best, not you must do this. But the word "should." It doesn't say all persons must remain at least 6 feet apart. It said all persons should remain at least 6 feet.
So you're reading it that
Yes.
the restaurant could be 1 foot apart.
Sorry?
Each person could be 1 foot apart, if that's what they want.
Possibly. And it's
That
not
make any
necessarily,
sense?
it's not necessarily what they want. It's a question of what can you reasonably do under the circumstances.
But that's not what it says either.
Well, it's...
If you're reading it "should" is not mandatory, then a restaurant, or let's use this place, could have been, every person could have been 1 foot apart, and that would have been okay.
Which is why what the lower court decided, which was that this was aspirational, is a reasonable reading of this provision.
All right, so now I'm going to ask you the same question that I asked opposing counsel. If that's a fair reading of it, what if we find that Mr. Kennedy's reading was also a fair reading? What do we do if they're both fair readings of it because it was just badly written?
Well, I think the court, even though there is no legislative intent, has to look at the circumstances under which COVID-19 Order 33 was generated. This was part of the governor's reopening plan. We were already 3 or 4 months into the COVID pandemic, and the purpose of Order 33 was to get businesses to reopen. And they had a very specific phasing of how it was going to work, what types of businesses, when it would kick in for each type of business. So to pick and choose words elsewhere in the order that talk about mandatory obligations and try to pin it back to this particular clause, which is clearly a should, not a must, would be, at least in my opinion, an improper reading of it. And I think it's incumbent on the court, if there's an ambiguity, it's a question of law, to resolve the issue of how it should be.
But well, what do you say to the argument that your brother makes about that we really have to read this language in the context of the pandemic? Because with a little bit of time, people might forget that a lot of people didn't make it through the pandemic, and that it was a terrifying time for all of us.
Precisely why the damage claim doesn't run back to March when the store first closed. It begins in June, after this COVID order was entered, after we contacted the franchisee, Mr. Kennedy, and said, what would you like to do about reopening? When is it good for you? Let's talk about this, to which he did not respond. And that's when, and this is what Justice Henry brought up at the very beginning, that's when Honeydew went down to the store and found out that there was a big for sale sign on it, the business was closed, it was closed permanently, and that's when they issued the notice. And the default on which termination was based was abandonment without consent. And that's really important because a lot of things could have happened, if the defendant had simply contacted Honeydew.
That's nowhere in the record. The judge
There is nothing about any
The
contact.
judge didn't consider that at all. The judge looked at the order and made a reading of the order and sided for your side. So what
Yes.
should have happened to me is irrelevant because of what she ruled on. So I want to go back to the order for a minute. And if you need to answer Judge Hodgens' question, go right ahead first. But on the order on page 3, it has the boxes. Your reading of it is that some of the things in the boxes are mandatory and some aren't? Because I need to know which ones you think were mandatory. Like when it says in the same box as the one we're talking about, it says require face coverings. Is that aspirational?
Require what, Your Honor?
Require face coverings or masks for all employees. Is that aspirational or is that a mandate?
Well, I have to say that I think analyzing specific provisions of the order as to whether they're mandatory or not is sort of beyond the scope of what we did here. I am looking at a clause that doesn't contain any mandatory language. It has 2 provisions that indicate it's not mandatory. Now, if I were running a business, would I have wanted people to be using masks? Yes. Was it mandatory under Rule or COVID Order 33? Possibly. But it's beyond the scope of the provision that we're dealing with.
Well, no, it's really not, because it's in the same box about social distancing. I understand it has a different, I forget what the little dots are called.
Bullet.
Thank you. It's in a separate dot, but it's the same paragraph. So if you're saying to me that it's either they're all aspirational or it's a mandate, and that seems to be a fair reading of it.
I'm not sure, Your Honor, because I think some can be mandatory where it's reasonable, and some may not be mandatory where it's either unreasonable or whereas here, the specific provision we're dealing with has language that hedges.
So an owner of an establishment, again, Mr. Kennedy in this situation, under your theory, should have opened, and if they had been, I guess, the police enforced, he gets penalized. And that's it. I mean, I accept your brother's argument that places were getting penalized during this time frame for not complying with this order.
I don't know if any food service establishments, fast food service establishments such as this one, which were cut out of the COVID order, the initial one back in March entirely because it was an emergency service. So I don't think that just because other types of businesses, such as a gym, might have had regulatory problems, we can read into that, well, okay, so this food service restaurant might have had regulatory problems. It didn't. There's nothing in the record about any food service establishment having any kind of regulatory enforcement action taken against them. So the bottom line is the provision that was written in COVID Order 33 has express language that makes it aspirational, as the lower court found.
And that language is the word should.
By using the word should and using the phrase to the greatest extent possible. I think that is the only fair reading of that clause. Because as Mr. Gens was talking about, when you have a couple people behind the counter, and I don't know what happens if one's in the kitchen and one's handling the counter, maybe then they'd be 6 feet apart. But he says if you go for ice, you may come within a couple feet of someone else. I think that's what it means when it says to the greatest extent possible. And they're talking about that because this order, at the same time, had restaurants reopening with servers going to tables.
Some with glass between them.
Some. But I don't think the servers were mandated to stand 6 feet away from the people giving the order and, saying, what would you like, sir? I mean, that would be an illogical reading of what the governor was intended, particularly in the context of trying to get the economy restarted and the businesses reopened.
I guess part of the issue I'm having is none of that, at least from what I read in the record, was presented to the judge. There was no examples of other places that were opening or not opening, just to be fair to both sides. So all the judge did, I guess in isolation maybe, was read this and say, I agree with your interpretation, it's aspirational. There's nothing in her order or her decision that talks about what was going on in the world. Is that fair?
And I think that, yes, and I think that should be affirmed. And I wanted to call to the court's attention that after this case was briefed, the Supreme Judicial Court decided yet another case dealing with liquidated damages clause. That was Cummings Property LLC versus Hines, 492 Mass 867. It was in September of 2023. It didn't really make any new law, but it repeated a lot of pre-existing law regarding liquidated damages clauses, which are relevant to this case. It said that parties are held to their word except in exceptional circumstances. That's on page 868. It said that liquidated damages do not always match actual damages, also on page 868. And it affirmed that you take a first look, a single look approach to the liquidated damages clause. In other words, was it reasonable at the time the contract was drafted? You don't go back a second time when the breach occurs and say, well, is it reasonable now? So that I understand that the, of course, interpretation of COVID Order 33 may make the liquidated damages clauses moot. I realize that. But I did want to point out that the defendant had the burden of invalidating the liquidated damages clause. He had to show that either the damages were reasonably ascertainable, which they clearly were not. In 2013, when this contract was negotiated, they didn't know when it would be breached, how it would be breached, what the economic circumstances would be, or they can show that the damages are disproportionate. And the defendant really didn't make either of those arguments in the lower court. They made two arguments. One was Order 33, on which I think they were wrong, and the lower court indicated he felt they were wrong. And as far as reasonableness is concerned, it was an argument that because you were using pre-COVID sales data and applying it post-COVID, that it was unfair. That was the only argument that they made on that. And that's taking a second look. That's what's expressly prohibited. So, all in all, I can answer any other questions, but we respectfully request that the opinion of the trial court be affirmed.
Any questions? Thank you very much.
Thank you.
Case is submitted. We'll be calling our last case, 2022 P1035 9 Clement Street LLC versus, and I hope I'm pronouncing this correctly, Lowry. Am I pronouncing your last name correctly?
Lowery.
Lowry, great. All right. So you'll have 15 minutes, and we have an opportunity to ask you questions. So you take a breath, and you're ready. We're very friendly. You go ahead. We're ready when you are.
Good morning. Good afternoon. I don't even know where we are, but good afternoon. So I'm just respectfully asking for you all to reverse the judgment that was issued on May 2nd. The reason that I am asking of this is because the council has stated during the I'm so sorry. I need a second. I apologize.
We understand.
My nerves. Okay. All right. So I'm just basically during the trial on May 2nd, they had stated that they were not accepting my raft payment funds, which they executed to do the eviction. Moving forward, the raft funds were cashed and were paid.
So that's where I want to stop you, because we don't tend to decide cases where there's not really a fight between the parties. And so they're arguing in their brief that once they changed their mind and they accepted the raft money, that they dropped the case, basically, and that we should just, we call it, legally the term is called moot. And so they're saying we should just order this case dismissed because this case essentially went away when they took the money. So my question to you is, are you still living at the premises?
Yes.
Okay.
I'm
And
currently.
do you, I know it's a legal argument, but do you have a reason why we shouldn't just dismiss, which would basically mean you win because the case goes away?
Yeah, I mean, currently right now, my lease was terminated as of October 1st, so I'm currently in the process of now being evicted. So moving forward there, you know, I have to bring my arguments from there with the new case that's being brought against me. They raised my rent to $2,000 and basically did not provide me with a new lease, and they terminated my lease.
And you understand that nothing we...
No, that's nothing you are. That's a new,
Right.
a whole new case that's being filed in court now.
Okay, continue.
So when you say moot, I don't know what these terms mean, but it's just dismissing the eviction completely?
That
from the May
old
2nd
one,
order?
yes.
Okay. That's what I would ask for.
Okay.
And then moving forward, you know, I mean, I'm looking for a new place anyway, but moving forward, I will bring my new arguments going forward.
Can I just ask you a question? So if the landlord was made whole by the raft payment that they eventually accepted, and this may have nothing to do with this particular case, but it's a curiosity. What's the nature of the termination of the lease in October? Was it that the date of that the lease was up?
So basically, I received a letter stating that they were increasing their rent to $2,000 from $1,600, and then I was given a letter that I was going to have a new lease to be signed, and then I got a letter stating that they're not they're not giving me a new lease to sign because I guess I didn't follow through with the agreement. I went to court on July 27th for another eviction that they proceeded with, and that was dismissed. And it was basically dismissed because there was a payment that I had to make of $1,600, which I made. That was the agreement. I had to make the $1,600 payment. The case was dismissed. Going forward, there was my neighbor had an accident or emergency upstairs, and they cut open holes in my unit, and basically it rained in my house for 3 months. They never came to fix it, and I called the Board of Health, so there's a whole new Board of Health case filed on them because it's the tactics they're using. And it's, so with that being said, they're saying that I didn't pay my rent. I withheld my rent because it was raining in my house 3 times a day. And because I had holes in my ceiling in my living room, ceiling in my bedroom, and I constantly, why are you not coming to close the holes? They fixed the problem upstairs, and for 3 months, I had buckets pouring in my house. The Board of Health came twice because, again, there was a new report refiled on this incident, and so, yeah, they finally patched up the wall after 3 months.
So I know there's an issue about a $550 cancellation fee for postponing the truck coming. Did they ever get that money or charge that money to you?
So there was, I made, okay, in July, so after the judgment in May, July.
And what year are we in? You said after the judgment in May of 20.
Yeah, I made a payment to United Properties for $2,086. I got another 30-day notice to quit in July after the judgment. And so when I got that letter, I didn't understand because I had received stipends from Raft for June and July payments. And so I was kind of confused. I made a payment because when I went up there, they told me it was for $3,000. I think the document's in there, but it was for a little over $3,000. But then they told me I only owed $2,086. I made that payment that day, and that payment basically is in there. I've never got my money back. They said it was applied to my rent, and it's just, I'm still trying to get that money figured out.
You gave us an appendix, and on pages 7 and 9, there's handwriting where these are basically a list of code violations to be corrected, and someone's written by hand, complete, or...
That was me.
That's you,
I did put in, because these reports stem from 2019, so this has been an ongoing issue with my landlord in neglecting my unit and having me live in these conditions for years. And so, yeah, that's what that's about. This is going back to 2019. And after I went to the Board of Health, and after the reports had been filed, these are just the tactics that they're using to remove me.
Now, you may not know the answer to this question, but do you see any connection between your lease being terminated in October and this particular case?
Yes. I mean,
and what's that?
I actually feel that when my last case on July 27th was dismissed, when they were trying to evict me, that was their next move. And I don't know if it's tied. I don't know really how to answer that. But I do see a correlation here. Like, there's a consistently trying to remove me. You know, I've been there for 13 years. So you know, yeah, so, you know, they raised the rent on me now from the 16 now to 2,000. And, I mean, I'm ready to go. But I have to just go forward with whatever they want to proceed with going forward. So.
Is there anything else that you think we should know before we hear from the attorney for the landlord?
I pretty much believe I put everything in my brief.
Okay.
And, you know, that's really the chain of events and how everything is going. I mean, I still want to know how they were able to even proceed with the new eviction in July, where payments were obviously received from Raft. I don't know how that went through, but it did.
Right. So I do want to be clear with you that for better or for worse, we do treat each attempt at eviction as a completely separate thing. So you need to make whatever arguments you want to make in that case.
Yeah, I'm going to make
don't
it
rely
in the
on,
current
yeah,
one upcoming.
but we'll just treat them as a separate. Okay.
Okay.
Thank you.
I believe that's everything.
Okay. Thank you very much.
Thank you.
I had a note that you were going to be sitting for the argument.
No, I will be standing.
Oh, okay. Okay.
Kayla Chattal will be sitting.
Okay. I just wanted to make sure.
Yes, thank you.
We're very sensitive about health issues after. If we weren't sensitive before the pandemic, we try to be sensitive now.
Appreciate it. Thank you. May it please the court, my name is Natalie Megaludis, and sitting next to me is my colleague Kayla Chattal. Attorney Chattal was the attorney that attended the May 2nd, 2022 hearing, which is the subject of today's appeal. I do want to start from the outset on some procedural issues before attacking some of the more substantive law issues, which has to do with the proceeding that occurred with this May 2nd, 2022 hearing. That was for purposes of identification, we'll call that the first eviction. There were two subsequent evictions, which this court has already talked about. There was a subsequent one that was also filed for non-payment of rent, and that was the one that Ms. Lowery was referring to, related to the July 2022 incidences and the payments that were received. That was the non-payment of rent case. There is a
And that was dismissed by you, right?
That was dismissed by us. It was, in that regard, that case was also, the landlord did accept, our client did accept the Raft funds. And on that basis, and while there was still the pendency of this case, and while there was a stay of an execution rendered by this court, and I understand the court's position that you take every case separately, but where this court had issued a stay on the levy on the execution, the landlord accepted the funds to be made whole, much like the landlord did in the first case. And that's procedurally, I know Ms. Lowery has stated that where the landlord had received the funds, or by accepting the funds, and in her brief stated that where the landlord had accepted the funds, the landlord couldn't then proceed to go forward on the eviction. The funds had been sent, but just to clarify, at that particular time and at that hearing on May 2nd, the landlord had stated they did not want to accept it, that they wanted to just go forward. But as the subsequently did accept it because there was a stay that was imposed by this court and they did not want for further damage. Then in July, there was a new eviction that was started. The second one, Raft was accepted for that. And now we're in a third situation. That one is brought for cause, and that one has to do with chronic late payment and repeated failure to pay rent.
And that's the one that's not before us, though.
That's not before us. Well, I would argue that the other, both evictions are not. The only one that's before this court is properly the one that resulted from the May 2nd, 2022 order. But the one that Your Honor is referring to is still open. It's pending. And a date has, a first tier or a first case management conference has not yet been held.
But it seems like you all are in agreement now that this appeal is moot because the landlord did change by subsequent events, the landlord did change their mind and accept the raft funds. Do you agree with that?
That's been our position. Yes, Your Honor.
Okay, so the thing I'm not sure about, though, is the $550. Did you move to amend the judgment to add the $550?
There was two instances where there were two judgments that were filed. There were several hearings in this case where there was amending of a judgment. There was one that was previously done, but it wasn't part of this appeal. It was in connection with a stay of an execution. I believe it was the second one. I'm confusing whether it was the February or the March dates, but there was one that was done, and in that case the judgment was amended. The one that's referring to, that Justice Henry, that you're referring to with the $500, that one was on May 2nd, 2022. We did not amend the judgment.
So if the case is dismissed as moot, there's no money owed, it's just over. Is that fair?
On that initial judgment that was rendered, yes, the landlord accepted the funds and made that determination based on the pending appeal and based on the hardship factors, yes. If there's no further questions
Yeah, well, so then the question I have is, there does seem to be, as you point out, Chapter 257 of the Acts of 2020 has expired.
Yes.
But the legislature enacted General Law, Chapter 239, Section 15, which has very, very similar language. It's not identical, but it's pretty darn close. And there's been a cry for us to interpret that. So my question to you is, do you feel like there's a reason why this case is a bad vehicle for us to do that?
I do, Your Honor, for several reasons. Well, I think that Your Honor is correct. I just want to address your point of there were two statutes. One was done obviously in the situation of the COVID pandemic, but I would submit that in enacting the subsequent law, Chapter 239, Section 15, there was opportunity to address a lot of things that may or may not have been entered into, or the language that was enacted as part of 257. And I do think it's telling that the language is pretty similar for all intents and purposes. And to be clear, the law that was enacted for 257 and similarly for 239 both speak to the authority of the courts having jurisdiction over housing matters. In no way, and they could have had an opportunity when doing the second law, which is currently in effect, to state that, somehow limiting either the cure rights of a tenant, which are stated under Chapter 186, Section 11, and it also could have modified the rights of landlords under 239, Section 3, which is exactly the same chapter, and they've now enacted the Section 15, which essentially also doesn't address substantive rights of landlords, which states that a landlord is not obligated post-judgment to accept a satisfaction of judgments once it receives the execution. So in its form, in both forms, it stands the same under 257 or 239. It clearly states that this directive was to allow for the process to occur, to allow for the applications to process, which sometimes can take 3, 4, 5 months. And it's gotten a little bit better, but it still takes a lot of time. But at the end of that, and I think where the court has ruled both in Chapter 257 or whether it would apply in 239, it still directs the housing courts to specifically not rule while these applications are pending, but it says the word pendency, and it doesn't speak to substantive law, it doesn't speak to substantive rights of landlords or tenants, and it clearly states that once the pendency is removed, there's no language that was enacted at either time, either at the time of 257 or currently under 239 Section 15, which states that the landlord is obligated to accept it, which is why, for Ms. Lowery's situation, the landlord, at a significant cost, elected and a burden, stated that they weren't going to accept it, but had to wait the process. And through that point, there was over $16,000 that was owed.
Do you think we should wait for a case to arise under Chapter 239, Section 15, rather than this case, which has arisen under Chapter 257 of the Acts of 2020?
I think the law is the same. I think that the circumstances are the same. I don't think that, I do think that in not changing the law, I think that where there was an opportunity to modify landlord or tenant rights, I think there was an opportunity to do so in 239, and I think it's telling that they did not. I think the language as it clearly states that in an action for summary under 239, but the language is very similar in 257, it clearly states, in an action for summary proceedment for non-payment of rent, a court having jurisdiction over said action for summary process shall, and it goes through the language. And it's a directive to the housing courts for process, but does not change cure rights for a tenant or satisfaction of judgment or waiver by a landlord. And I think the housing court judge in this case, in Ms. Lowery's case, alluded to that and stated that I don't read anything in Chapter 257, and I think the language would be the same, 239. I think aptly and appropriately stated, I don't read anything in this, and it doesn't state anything in here that would substantively change the rights of either a landlord or a tenant that constitutes a waiver. And I've also cited it, we cited in our brief at page 16 a case, it was Stanley versus Dixon, where there's a central housing court decision that actually ruled on 239, which essentially held that nothing under that statute changes it, and they don't read anything into that. And if they would have done, if there was an intention to do so, the opportunity to change the obligations would have been done in that statute. And I think that the silence is indicative of the fact that there's an intention for it to be binding on the housing courts and the authority of the courts.
This is a bit of a tangent, but what is the obligation of the landlord as far as cooperating with the tenant in the application for raft?
Whether there's an obligation for a landlord to process it. I think that there's always, I'm not aware of any obligation. I would certainly suggest that in going through the process, a landlord cannot, by virtue of, and I think it would be discriminatory to say, I'm not doing raft process, right? I think that would be on its face discriminatory, similar to the argument of, I don't do Section 8, or I don't do, other types of subsidies. The source of the funding shouldn't be part of the determination, and where the funds are coming from. And because they're public funds, a landlord can't say, I'm not going to engage in that. I think that the process of working with a tenant in order to receive payments, regardless of where the source of the funds comes from, is still within the election of the landlord. In some situations, the landlord, as in this case, may say, it's too long. It's too much money. I don't want to continue to do this. I don't want to have to file a second summary process action or a third summary process action. At some point, where a tenant is either a tenant at will, who has a month-to-month tenancy, or under a lease, at some point the tenancy can end. And a landlord, in that regard, may take that into consideration in deciding not to engage in the process of accepting funds, regardless of the source.
But why should they be able to, you're saying the law requires them to be part of the RAF process, but then why should they be allowed at the end to say, but no, we're not going to take the money?
Because of 257 and 239. I don't think that that's an election by the landlord by any means. I think that it imposes this inability to get an execution because it ties the hands of the housing courts to not issue an execution. So it's not really an election as much as it is just a cause, just an effect of it. Certainly, if the landlord would want at some point to say enough, which they do, and in this particular case, Ms. Lowery's was accepted, but in some situations the landlord would want to. But that's the situation. And it comes at a prejudice to both the landlords and the tenants. I mean, the landlords has to wait this whole time. I do think that, tenants, waiting on this and waiting on this and waiting on it also causes some issues. But in this particular situation, the judge notably extended and did continue put a stay in the execution, I think for about 2 weeks. For Ms. Lowry's situation.
So I'm a little confused about the $550. I know I asked her about it. I apologize if I've asked you, but could you just, so that you said it didn't get amended, and then was she then later, after this case was overcharged to the $550? Or no, I don't want to do that. That's outside the record. Was she charged the $550 in this case, or did that just go away?
She was charged for the initial $500, and I know that was put on the ledger.
I'm talking about from the May 2nd, 2022.
I'm not aware of the second charge being put onto the ledger. Okay. I do believe, well,
but if it was,
I'd have to go back and look, because there were some additional charges that were put on subsequent. I do believe, though, that they were satisfied as part of the second draft application, if my memory serves.
But they weren't. I'm just going to mootness. You think there's no live issue. I think you said at the beginning of your argument that the judgment in this case was not modified to add that extra $550 from May 2nd, 2022.
Correct. The judge gave leave to file a motion to amend the judgment, which we did not.
Okay. All right. Thank you.
Thank you. Thank you.
Thank you very much. The case is under submission, and I just want to, that's the end of our session, so I want to thank our staff, our court officers, and our clerks, and everyone who assisted in today's argument.